All right, hello everyone, and welcome to our Tag Inspector webinar here today. Today we'll be covering everything that you need to know about the GDPR. It's obviously a hot topic with the new regulations rolling out here in the EU. So I want to take everyone through the basics of what you need to understand about the new regulation, privacy, things you need to be taking into account, and then also applying it back to specifically the analytics and marketing and advertising space. So to start, general formalities about Tag Inspector and me, Lucas, your presenter. So I am your presenter, Lucas. I'm our Tag Inspector product manager and also a tag management consultant. So work with a number of clients on tag implementation, data collection, tag governance, and it all rolls up and is obviously applicable here with the GDPR. For anything that is collecting data on a website and how it's being used and all that good stuff. A little overview, Tag Inspector is a product of InfoTrust, LLC. InfoTrust, we are a web analytics, tag management, and product development company. We work with several thousand websites on an annual basis. We do a number of digital marketing and training programs every year as well, including these Tag Inspector webinars and the one that you will be enjoying today. We have offices in the US, in the UAE, Dubai, as well as in Spain. So global presence, working with clients everywhere. Obviously this topic becomes very, very pertinent as a result. General disclaimer, this is not legal advice. I'm not a lawyer. So anything we covered today, I want to give you a really good understanding. We'll be going through the actual law and the regulation, but before you make any sort of legal decisions or legally binding compliance decisions, things like that, please consult your internal counsel. So to quickly run through the agenda that we'll be covering today, first we'll be just walking through GDPR, and then also we'll be touching a little bit on the e-privacy directives, the difference between the two, what each covers. Most of the focus, really 90% of the focus here is going to be on GDPR, but the e-privacy directives that are in place and that are being worked on right now are also relevant in some of these different areas, especially when it comes to analytics and some of the consent items. So we'll be touching on that a little bit, so just want to cover some of the basics here in that initial overview. We'll be going through the 6 principles of GDPR. These are the primary 6 tenets and the things that are really important need to know. We'll be walking through the different lawful basis for processing, which is going to be extremely relevant. You're going to need a lawful basis for processing or collecting any type of personal data from clients or users of your website. We'll go through the rights for individuals just to make sure that all of those rights are adhered to and upheld in all of your different data collection as well as processing activities. We'll go through some of the highlights for accountability and governance, things that you're going to be accountable for, what you need to make sure that you have in respect to that. We'll go through a specific piece on the privacy notice, which that's going to be huge. One thing that really needs to be reflected, all of the different data collection activities and processing activities that are happening for information that's collected from your users, all needs to be reflected in the privacy notice. So I want to go through a specific section on that to make sure that you have all of those different items covered and to start thinking about some of the things that you might need to be doing to really beef up and strengthen your privacy notice. And then finally, at the end, we'll go through what this means for you. So we'll take the learnings that we have through the first 6 sections, and we will apply it specifically to the analytics and the digital media or advertising space, and some of the initial steps that you should be taking and things that you should be aware of. At the end, we'll do a summary and a Q&A. We're using GoToWebinar here today, so you have the ability to drop questions in at any point. Please do so throughout the presentation. All those will be aggregated, and then I will go through them at the end. And we can walk through any questions that you might have and provide any further clarification. If there's any questions we don't get to, I'm more than happy to follow up, and we will follow up just via email with the email that you registered with. Cool. So let's get started. So first thing that we want to cover is just the GDPR and the e-privacy directives. What are they? What are the differences? What does each cover? So GDPR falls under the category of regulations. Regulations we need to understand their law as written. So it applies to all EU member states, and basically what is contained within it is the law. GDPR is a regulation, and it sets out to protect the fundamental rights of individuals. It's general, it's not prescriptive, but it protects those fundamental rights, making sure that any data collection, data processing is lawful, fair, and transparent. The second thing is your e-privacy directives. Directives are a little bit different, and then in that they are special and they're specific. They apply to specific things. Some of the examples for the e-privacy directives that are currently in place across the EU are directives for like how you handle telephone, email, SMS, app, or over-the-top marketing. Some different specifics for like a B2B versus a B2C marketing activity. Also covers things like purchase and soft opt-in. The biggest difference here is directives are they're not laws written. They're basically a direction, and then each member state has to then create and apply their own specifics. So it's one of the reasons why right now you'll see differences between like cookie consent policies, opt-in, opt-out from one country to another. It's working on kind of being solidified and codified right now to be applicable across the entire EU, but as it stands right now, that's what those directives are. Basically, in summary, GDPR protects the person and their fundamental rights. E-privacy protects specific things such as like an email address or another personal identifier. To get into just a general overview of GDPR and cover a couple of important definitions for things that we're going to be covering throughout. So first is the general intent of the regulation. As mentioned, it is meant to instill basic privacy rights as human rights, and all that's in relation to personal data of a subject or of an individual. The real big goal here is to force organizations to demonstrate thinking about privacy. The goal and the intent of the regulation isn't to hand out large fines. It's to just force organizations to think about privacy and really put privacy practices in place throughout the design and the execution of any sort of data collection that they're doing on a website or even offline. Speaking of those punishments, what they are, so as most people have heard or understand, punishments for GDPR breaches, there's two different classifications. And these are the punishments that can be administrative fines that can be handed out by the governing body. So the first one is a punishment of up to 10 million euros or 2% of annual global turnover, whichever is higher. This type of a fine basically covers obligations that apply to a controller, a processor, or certification body, or even of a monitoring body. Basically what that first class is if you failure to notify of a breach, or you don't uphold your obligations in the event of some sort of a breach. The second classification is punishment of up to 20 million euros or 4% of annual global turnover, whichever is higher, which obviously is huge. This particular punishment is would be handed out on any sort of a breach or a failure to or a breach of the regulation in the case of processing, as well as a failure to protect human rights. So if you are doing unauthorized personal data collection, profiling against people, and then using that for legal harm against them, which we'll cover each of those here later on, those are the types of activities that would put you in that second category. Now, it's important to remember as well, though, that the GDPR sets out and allows for compensation claims for damages suffered by an individual. So if an individual can prove that as a result of some sort of personal data point that was collected, or personal data that was collected, and then there was some sort of an adverse effect on them as a result due to how it was processed, how it was used, they have a right to file a compensation claim against that organization. Now, where this gets really scary is in the case of multiple individuals that come together for like a class action lawsuit. And so that can be a really, really large type of punishment, financial as well as time and just legal issues that an organization could face. The final piece here for punishment's a little bit more intrinsic, but obviously you have reputation damage and loss of consumer trust. So if you're on the front page of the newspaper as being non-compliant with GDPR and being lackadaisical with users' privacy, that's obviously a poor reflection on the organization, as well as going to cause some damage to the business moving forward. A couple of things just to keep in mind though, when considering fines, it's been laid out, the governing body will take other considerations into account. So did you have processes in place? Did you think through, was it some sort of a mistake that just kind of made it through the process? Once a breach occurs, are you taking actions in order to be able to mitigate any type of damages? Those types of things are going to be taken into account when administering those fines. So it's extremely important, and we'll hammer this home throughout the webinar. You need to document those different processes. You need to have processes in place around privacy, and you need to be able to defend yourself in the event of a regulatory body starting to ask you questions. Another thing that's important to remember is that you are not the only one that's affected by this regulation. Everyone is. I like to say that GDPR is a bear. There's a lot there. There's a lot of ambiguity. There's a lot of things to cover. And as kind of the story goes, if you're being chased by a bear, you don't necessarily have to be the fastest person. You just need to be faster than the person next to you. So everyone's affected by GDPR. It applies across all organizations. If you have a lot of these different processes in place, you have the necessary documentation, you've thought through and you've documented the privacy process, you're going to be one step up ahead of someone else. And those more egregious offenders are going to be the ones that are really going to have that spotlight on them. One other quick note here about how you're not the only one affected and about these different fines. One thing that has become very apparent throughout the clarification process for a lot of the different pieces, regulatory bodies are working on crowdsourcing guidance. They put out clarifications, they invite feedback, they then take that and then provide additional clarification. So many of the governance boards, they lack digital experts in their regular teams. So again, there is a little bit of leeway when it comes to the privacy measures that companies are enacting, especially when it gets really, really complicated. So again, as long as you're taking those steps needed to be reasonable and defensible in the different positions that you're taking for the processing of personal data, the collection of personal data, you have a defensible position, and instances like that should just result in a warning and some sort of remediation that needed on your end before those fines come into place. Want to go through a few different really key important definitions that we'll be touching on throughout, and words that we'll be using throughout. So the first is the controller. So it determines the purpose and the means of processing personal data. So this would be you as an organization determining what different platforms you're using for analytics, for advertising, for marketing, determining what information is collected, what those forms look like, the overall general architecture on your site for how different data points are being collected, those sorts of things. The second piece is the processor. So the processor is responsible for processing personal data on behalf of the controller. A good example here, an easy example here is if you are a website using like Google Analytics for the purposes of your web analytics, In that case, you would be the controller. You're determining what data points are being collected, what's being sent, how that data is being used, and how you're analyzing and utilizing that information. The processor in this case would be Google, because they're processing that information on your behalf to be able to utilize and to leverage within that reporting. Who does GDPR apply to? This is a common question. GDPR applies to any organizations that are operating within the EU, any organizations that are offering goods or services to subjects within the EU. So if you're located within the EU, applies to you. If you are outside of the EU, but you offer goods and services or market to individuals within the EU, it also applies to you in those different cases. GDPR confers rights, those privacy rights, to anyone that is within the EU. Personal data is one thing that we're going to really be touching on quite a bit. Any information that can be used to directly or indirectly identify the identity of a natural person. An important clarification here as well. Pseudonymized data can fall under the scope of GDPR depending upon the difficulty to attribute the pseudonym to a particular individual. So a lot of people think like, oh, I just collect, a random client ID for, this particular cookie ID. It doesn't have an email address, doesn't have any of that. Depending upon what your overall data set looks like, and if you can use that random ID, I guess, for an individual person or for an individual, if that key or if that ID can be used along with the other pieces of your data set in order to be able to directly or indirectly identify that individual, then that piece of information that you're using as the key would fall under the definition of personal data. So this is going to be really, really important when we talk a little bit later about implications for analytics, for advertising, for media, because oftentimes we are collecting some sort of an anonymous ID, but that is then used as a key to pull in a lot of other context. Using all of that other context, you are able to indirectly identify an individual. Processing is any operation performed on personal data or on sets of personal data. So one note about processing, this can include things like collection, recording, organization, structuring, just the use, disclosure, consultation, all of those different things that you're doing with data. So if you are running a report on data, that's processing. If you are just retrieving information that's maybe in a spreadsheet, that's processing. If you're collecting information from a website, or you're setting up the tag architecture in order to be able to collect information or behavior of users, that's processing. Processing applies to basically any action that you're taking with personal data. So that is kind of just the overview, what GDPR is, what it applies to, what some of the main definitions are within it. In terms of the next thing we'll cover is the 6 principles of GDPR, and these are kind of just the basis, the foundation of it. So what these do is refer to what personal data shall be, or the core, the foundation of the protections that you need to have in place for personal data. So the first one is that personal data shall be processed lawfully, fairly, and in a transparent manner. So basically what this means, you need to have a legal basis for processing information. Processing must not cause damage to the subject, must be fair. And then the individual needs to have visibility into the processing of their data. So what is collected, why is it used, why is it collected, what is the end result of that personal data being collected, how is it used, how is it applied, and then how does that come back and potentially affect that user. The second principle is that personal data shall be collected for specified, explicit, and legitimate purposes, and not further processed in a manner that is incompatible with those purposes. Further processing for statistical purposes shall not be considered to be incompatible with the initial purposes. So basically what this means is data must be used for the explicit reason for which it is collected. So you need to define an explicit reason for why you're collecting or why you're processing a user's personal data, and it must be only used for that purpose. Number 3, personal data shall be adequate, relevant, and limited to what is necessary in relation to the purposes for which they are processed. So you must collect only the minimum amount of personal data in order to be able to accomplish your stated purpose. Number 4, personal data shall be accurate and where necessary, kept up to date. An extension of that is that every reasonable step must be taken. Inaccuracies must be erased or rectified without delay. So data must be accurate and clean. And then in the event that inaccurate data is detected, either by you, by a user, by another controller or processor, that must be rectified immediately or erased. Another important piece here is that if you share data with any other processor, with any other controller, you need to notify them of that inaccuracy and update them so that they can also update that inaccurate record. Number 5, data must be kept in a form which permits identification of data subjects for no longer than is necessary for the purposes for which the personal data are processed. This just distills down to you can only keep data, or data can only be kept for the amount of time that is necessary. If information is identifiable, and it needs to be identifiable for the purpose of whatever it is that you are doing, the processing that is taking place, it must be obfuscated or deleted as soon as the purpose for processing is complete. Number 6 here is data shall be processed in a manner that ensures appropriate security of the personal data using appropriate technical or organizational measures. So basically, you just need to have processes in place internally to protect the personal data of individuals. Now, those processes can be both more on the business administrative side, just different checks and balances in place, as well as on the technical side, which we'll hop into and discuss some of those different technical specifics here a little bit later. To summarize in kind of one paragraph, what needs to happen: data shall be, personal data should be collected for a specific, legitimate purpose. Collection should be limited to the data points that are necessary in relation to the purpose set forth. Data should be processed in a legal and transparent manner. Processing should be done in a way that ensures appropriate security of personal data and should not occur for a longer period than necessary. And then finally, all collected data should be kept up to date and accurate at all times. So those are the 6 basic principles that GDPR lays out, and then everything else is kind of different applications of that and feeds up into those different 6 principles. So whenever you're going through some sort of thinking about, does this apply to GDPR, or yes, this is personal data, what needs to be kind of taken into account, these 6 items are the bases that you should really be thinking about. An important point here also, Article 5, Section 2, the controller shall be responsible for and be able to demonstrate compliance with the principles. The onus is on the controller. So if you are the site, or if you're an agency or something and you're working with the client, even if you're processing information on behalf of that client, you may fall under the classification of a controller if you are determining, independent of that client, how exactly data should be used. Any processing that happens, from collection all the way through deletion, that entire life cycle, any processing that happens by another party, or if there's a breach with one of the processors that you're using, at the end of the day, the controller, the one that is setting out and defining the purpose and the use of the data, is the one that is going to be responsible. So you need to have everything documented for your decision-making process for the collection of information. And you also need to have contracts in place, data sharing agreements in place, things like that with your processors, to be able to make sure that they are also compliant with GDPR. If they are doing something that's nefarious, you need to be protected legally in that sense, and realistically, you need to be aware of that and maybe use someone else. So these are our responsibilities when it comes to collecting and processing personal data. The next thing I want to cover is under what conditions is it legal for us to actually collect this information. This is huge. Lawful basis for processing. That's one of those first items in that in those different 6 principles. Personal data should be processed lawfully, fairly, in a transparent manner. So it all starts with a lawful basis for processing. So what are these? There's really, some of the basics first for the lawful basis for processing. Processing must be, or the lawful basis must be determined before processing happens. I can't stress that enough. You need to get it right the first time. You cannot just change your legal basis on a whim without a really good documented reason for doing so. If you're collecting information on the basis of legitimate interest, or if you're collecting information on the basis of consent, and then all of a sudden you realize like, it's kind of difficult getting consent, let's switch this over to legitimate interest. That information that you've already collected, if you were doing so unlawfully, or in a way that was not in the way of your explicit stated basis for processing, that's going to be a violation. Another kind of cornerstone here is that the lawful basis for processing must be necessary. It must not apply, or the lawful basis will not apply if you can reasonably achieve the purpose for which you've set out for the processing or the collection of that personal data by some other less intrusive means. So you need to think through, how can we accomplish these different goals that we're setting out to accomplish, and can we do so without collecting personal data? If so, you're not going to have a lawful basis for processing. Your privacy notice should specify the lawful basis that you're using for which that data is being processed. And then as it works out, there are 6 lawful bases available for you to have a lawful basis for processing. Now, to quickly walk through what those 6 are, a lot of things, especially in the marketing space, people get caught up in consent. Consent is just one of 6. So the first lawful basis for processing that you can use is a contract. So if the processing of personal data is required in order to be able to fulfill a contractual obligation, or because the subject has asked you to do something before entering into a contract, an example might be providing a quote, then that would constitute a lawful basis for processing. Second basis is a legal obligation. You can rely on this lawful basis if you need to process the personal data in order to be able to comply with a common law or statutory obligation. So if you, as the controller, have some sort of a legal obligation for which you need to collect personal data, that would be a lawful basis for that processing. Number 3 is vital interests. Vital interests, you're really not going to use for marketing. Vital interests can likely be used if you need to process personal data in order to protect someone's life. So it does not, though, apply if someone is able to or can give their consent in any sort of way. But that is there. If you need to process personal data to save someone's life, that's a lawful basis for doing so. Number 4 is a public task in the exercise of an official authority, is basically what that means. This covers public functions and powers that are set out in law, or to perform a specific task in the public interest that is set out in law. This would really just apply to public bodies. Now, the last 2 we're going to cover in much more depth. The first is going to be legitimate interests, and the second is going to be consent. For the purpose of marketing and advertising data, we will be working with either consent or legitimate interests. So those are the 2 that you really need to focus on and you really need to understand. Starting out with consent, because that's kind of the hot topic that everyone wants to cover and to really focus on. So we want to focus on consent if you prefer to give subjects full control over and responsibility for their data. One note, just in general about for consent, there is still some ambiguity. Like I mentioned before, the governing bodies do put out clarifications for different pieces of the regulation. Consent was one of them. They put it out around the end of last year. They got a bunch of feedback. That closed in January for the feedback. The final clarifications for consent have not yet been released. They're not expected to be released until the first or second week of April. So there is still some ambiguity around consent. So we can really just go off the basis of what is written as of now, but there will be some clarifications upcoming, hopefully not too close to that May 25th date. But what you need to know about consent. So what changes under GDPR versus as compared to the current climate, which consent is really covered by the Data Protection Directive. So Data Protection Directive right now, what it states is that any freely given, specific, and informed indication of a subject's wishes by which the data subject signifies his agreement to personal data relating to him being processed. GDPR takes that a little bit further and states any freely given, specific, informed, and unambiguous indication of the data subject's wishes by which he or she, by a statement or by a clear affirmative action, signifies agreement to the processing of personal data relating to him or her. The huge difference here is that GDPR clarifies that the indication must be unambiguous and provide a clear affirmative action. So what does this mean exactly? So under GDPR, consent must be explicit. So some of the requirements that are set out here: no pre-ticked boxes and no implied consent. Right now for cookie collection, even for advertising platforms, which oftentimes that cookie ID is going to be considered personal data, sites will use if you continue using this site, you agree to our use of cookies. That's implied consent. That's not allowed under GDPR. So you cannot have any pre-ticked boxes or any implied consent. The statement of consent the statement of consent must be clear and specific. So it must be clear exactly what the individual is consenting to and specific to the platform and for the use of that processing. Consent must be separate from other terms and conditions. We see this oftentimes with like form submissions for an email, for example. A lot of times people will bundle together privacy by checking this box. Do you agree to our terms and conditions as well as our privacy notice? That is not allowed. It must be unbundled. It must be explicit consent agreeing to the terms of that privacy notice and the processing of that personal data. It must be specific. Vague or blanket consent is not enough. So you must be specific for the different pieces of personal data that are being collected and the different categories of processing that's going to be happening. All third-party controllers that are relying on that consent must be named. So any third-party platforms or tools that you're using in the marketing and advertising space must be named in that notification. You cannot use consent as a prerequisite for service. So you can't say you will only be able to continue using my site if you agree to our privacy notice. There is a specific right given to individuals to withdraw consent at any time. And it's important that the withdrawing of consent must be as easy to do as the actual consent. So that is clear as well. Have to give people the opportunity to withdraw consent at any point, must make it easy to do. One note is there is no set time limit for consent. So if someone consents, technically, they're consenting for an indefinite period of time. but that time limit needs to be based upon context. So you need to have a documented reason for why you're saving a cookie for, with a 2-year expiration date, or why you're holding on to someone's email address for 5 years. If you have a legitimate reason, document it, write out the logic, and have that ready to go, and you have a defensible position. But you need to be reasonable, and your reasoning needs to be defendable. There are also a number of different consent request messaging requirements. So those consent requests must name the organization, must name any third-party controller relying on that consent, why you want the specific data, what it is that you'll be doing with that data, and then also notification that consent can be withdrawn at any time. Another key here is maintain evidence of consent. If you're using consent as a basis for legal processing, if someone comes knocking on your door and says, why am I receiving this? Or why am I getting these emails? Or why am I, XYZ? You need to be able to demonstrate that you did lawfully get consent under these guidelines set out within the GDPR. So you need to know who consented, when did they consent, how exactly was consent given, what was told to the subject or what was consented to. And often a lot of recommendations are to use some sort of a privacy portal, so people can just manage their consent options for different platforms and for different categories of data just within your website. It's gonna make it a lot easier. It's gonna make it a lot easier also to manage that documentation process. So that's consent. Consent is difficult to obtain, but it's easy to defend. You have a record of consent, you can say, nope, this person said that collection of that personal data was perfectly fine. So easy to defend in the case of any questions being asked. The next piece is legitimate interests. So legitimate interests, as laid out, this is the actual text from the GDPR, processing legitimate interests are a lawful basis for processing when processing is necessary for the purposes of the legitimate interests pursued by the controller or by a third party, except where such interests are overridden by the interest of fundamental rights and freedoms of the data subject, which require protection of personal data, in particular where the data subject is a child. So unpacking that, which we'll do here in the next several slides, but one super important note to make about legitimate interests. In GDPR recital 47, which recitals are a bunch of different clarifications that are put out in the front of the overall document if you are looking at the actual regulations. But recital 47 states, the processing of personal data for direct marketing purposes may be regarded as and carried out for legitimate interests. Now, this doesn't give you carte blanche to, oh, no, marketing is legitimate interest, I can do whatever I want with it. There's a few different tests that you need to go through, but as long as you pass those tests and the benefit to you or to the individual outweighs the potential harm to the individual, then that legitimate interest can be used as a basis for marketing and advertising data, or for the processing of marketing and advertising data. An important note as compared to consent, so like I mentioned, consent is difficult to get but very easy to defend. Legitimate interest, on the other hand, is much easier to get but much harder to defend. You would use legitimate interest if you wish to keep control over processing, and also if you want to have that responsibility for demonstrating that the processing is in line with people's reasonable expectations with no unwarranted impact that is going to happen to them. So some of the requirements for legitimate interest. You must show that the use of personal data is proportionate. It has a minimal privacy impact, and people would not be surprised or likely to object to the use of their personal data in that particular way. You need to be able to check also that it is compliant with privacy directives. Privacy directives also apply. GDPR doesn't just supersede everything. I mean, it does. GDPR applies to everything, but each country currently it still has their own different privacy directives. An example would be PECR in the UK. For this particular example, it requires consent for storage or access of information stored on a user's browser or device. PECR in the UK specifically refers to that. That's what most of those different privacy directives are referring to. So in that case, those directives mandate consent and notification, although here consent can be implied. So if you're using legitimate interest, for example, for the collection of marketing or advertising data with the use of cookies, which are considered in most cases personal data, you could use legitimate interest as your lawful basis for processing, but due to those different privacy directives, you also need to allow consent, even if it is implied consent. And then also notification to the individual, again, just what is being collected, what it's used for, and all of that should be reflected within that privacy policy with the easy ability to opt out. One note also on those privacy directives, there are updates being made currently to the e-privacy regulation, which is expected to come out in probably 2019 or 2020. As it's written right now, it would require explicit consent for the cookie behavior. So GDPR would still allow for legitimate interest, but that new e-privacy regulation that's being worked on right now is possibly going to require explicit consent for the collection of cookie data and the use of cookies. So that's one thing to keep in mind and keep your kind of eye on because this space is changing. So 3 elements that are required for legitimate interest. First, you have a purpose test, which you have to be able to identify a legitimate interest. You have a necessity test, which you need to be able to show the process is necessary or show that processing is necessary in order to be able to achieve your stated purpose. And then you also have the balance test. The balance test is what you're going to use to balance the interests of the organization or your business against the subject's interests, rights, and freedoms. So we need to be able to prove these different 3 elements to be able to use legitimate interest as the lawful basis for processing of personal data. It's also important to note you must include the details of the logic that you're using for this legitimate interest as the basis for lawful processing within your privacy notification. Also, in the context of marketing, the right to object is absolute. You must stop processing as soon as someone objects. So, when it comes to legitimate interest, what you need to do in order to be able to make sure that legitimate interest is going to hold up is do a legitimate interest assessment. And you need to keep a record of this for all cases in which you're applying it. So you need to identify the legitimate interest, asking questions such as, why do you want to process this data? Who benefits from processing? How important are the benefits? Would your use of the data be ethical or unlawful in any way? You then need to apply that necessity test. So does processing actually further the stated interest? Is this a reasonable way to accomplish the interest? Is there a less intrusive way to accomplish the same result? If we can affirmatively, answer all of those, we can keep going. And then we finally need to do our balancing test. So what is the nature of your relationship with the individual? If the individual is a current client, past client, something like that, we're going to have, a little bit more leeway when it comes to the processing of their personal data. Is it any of the data that it's sensitive or private? One question that I like is, are you happy to explain the processing to them? Is it kind of sketchy or nefarious in any sort of way? Or is it something that, yeah, we do this, it's perfectly fine, and people would have a reasonable expectation that that would be done with their personal data? And then a few other questions there, but then also, can you offer an opt-out? So we need to apply these 3 different tests. We need to weigh the different options. And then if we can, reasonably and defensively say that, yes, the legitimate interest, the benefit, and what we're getting out of this and what the user's getting out of this outweighs any potential concerns for the individual's privacy, then you can use legitimate interest as your basis for processing. Super important to note, there is no set formula as of now for like a balancing test. Make sure that you're confident in your stated interest outweighs the risks to the individual. You need to make sure that it's all documented, and it needs to be defensible. Again, defensible in the event of being looked at further by a governing body. You also must be transparent in your privacy notice that you're relying on legitimate interest, and clear and transparent in explaining what those interests are. Cool. So next, rights for individuals. What are the individual's rights? Basically, they break down into 6 different things. An individual has the right to be informed, which is you just must be transparent about your use of personal data, typically done through a privacy notice. User or an individual has a right of access. They have a right to access their data and also any supplemental information, which is typically going to be in the details, again, of your privacy notice about what was collected, how it was used, what processing is happening, that sorts of things. 3, they have a right to rectification. So people have a right to having their information rectified if it is inaccurate. They have a right to erasure, which many people refer to as the right to be forgotten. Which this is just the right of an individual to have their data deleted or removed when there's no further reason for processing. Number 5, the right to restrict processing. This is a right to just block or stop processing of a person's personal information at any time. In many cases, you can continue to store the data, but it must not be processed any further. And then finally, number 6, they have the right to data portability, which this applies to their right to receive data from you in a clear, usable format so that they can then take it to another controller to be able to use. In some cases, it might be required that you transfer that data to another controller, but there is not it's not a requirement that you maintain or create processes in order to be able to do so at any point in the future. Number 7, for the rights of individuals is the right to object. People have a right to object to processing based upon a legitimate interest, processing for direct marketing, and processing for purposes of any sort of research and statistics. Basically, they just have the right to opt out and say, no, you can't do that. You must inform subjects of this right at the first point of communication within your privacy notice if you are using legitimate interest. And then you must offer subjects a means of opting out or a means of objecting. And then finally, there are rights in relation to automated decision-making and profiling. Basically, profiling is going to be any automated decision-making that results in a decision without any human involvement. Now, this becomes much more pertinent due to how we, use big data and profiling for people within the marketing and advertising space. Even if it's, taking a bunch of different behavioral characteristics or things that they've viewed or things with their cookie profile, and we're running some sort of automated means to, put them in a preference category, that's going to fall under, that's going to be defined as profiling because there's no human intervention involved. GDPR restricts you from making these automated decisions in cases where a legal or a similarly significant effect on users can occur. The effects aren't defined within the GDPR, but it must be a decision that's going to have a serious negative effect on an individual in order to be able to be caught by this provision. So an example here would be like travel sites. They'll use cookie profiles and offer different pricing for hotels or for flights based upon that cookie profile. Things like that would have a negative effect on the individual in like a legal sense because it's adjusting the terms of a contract based upon a cookie profile. Those sorts of things would be caught up in that GDPR provision. But in most marketing and advertising cases, it's not really going to apply since there's not a legal or similarly significant effect. Must still comply with the GDPR principles that we've gone through. They must still have these same rights, and you must have just a process in place so people can exercise those rights. But it's not going to have those additional restrictions. Accountability and governance, which we'll go through quickly here because I know we only have about 10 more minutes. So Article 5.2, again, from an accountability standpoint, you are required, or it is required that you can demonstrate compliance with the 6 principles. And then GDPR also explicitly states that that responsibility is your responsibility. So you need to be taking organizational measures, putting in place pieces of privacy by design, data protection by default. Basically, that just means you need to be thinking through privacy for any new platform that you're onboarding, any new data collection that you're doing, any marketing activity. You need to be able to think through and identify, is there personal data being collected? If so, what is my lawful basis for processing? Are we taking the appropriate measures in order to be able to protect our users' rights? You need to have documentation around all of those things. So your privacy notice, any records of consent, controller processor contracts, making sure those data sharing agreements are in place, data protection impact assessment reports, which would just be you walking through that logic of, is it okay for me to collect this? Is it not? Why am I? What is my basis and what is my logic for doing so? And then you also need to maintain any records of data breaches. An important thing is to just map your data flow. Walk the data, understand where are you collecting personal data, what is it used for, where does it go, what are the processors then involved, are there any other controllers involved, do I have the necessary agreements and documentation in place in order to be able to have a reasonable and defensible position in relation to that processing. There's also a number of technical measures that you can put in place or should have in place. These types of things would be like data minimization, transparency, creating and updating security features on an ongoing basis. Those are things on the back end should be being taken care of by security, but they need to be in place. Next thing, I want to just quickly go through some of the items for the privacy notice. Really the important things here, items to cover when you're planning. So what should be included, the basics. Identity of who you are, so who is the controller and the data protection officer, if applicable. The purpose for collection, the legal basis for using processing. If you're using legitimate interest as your basis, what that legitimate interest is. What category of personal data is collected or processed. Retention periods for that data. If you're sharing personal data in any way, who with, why, for what purpose. And making sure that proper safeguards are in place, as well as proper documentation, legal agreements are in place. And we can do all that just by mapping information processing, thinking about some of the other items that we need to work out, some of those other implications of the personal data that we're processing. And then all of those things need to be reflected within your privacy notice. As I mentioned, if you're sharing data with other controllers, you have to identify who it is that you're sharing data with. You need a data sharing agreement in place with all those controllers involved. And you just need those protections, and that transparency needs to be available to the end user. GDPR requirements basically for the privacy notice also are in play here, obviously. The requirements are that the privacy notice must be concise, transparent, intelligible, and easily accessible, must be written in clear and plain language, and it must be accessible free of charge. Perfect. So finally, what does this mean for you in the analytics space, in the advertising space, in the digital marketing space? So first, when it comes to web analytics data, only potentially is there personal data that would be collected. So if you're not collecting things like a user ID, email address, if you're not combining analytics data in the back end with other data sets, you likely don't have personal data under the context of GDPR because the data that's being collected cannot be used to directly or indirectly identify a natural person. Now, as soon as you start combining that information together with other data sets, as soon as you start adding some additional context, and as soon as you get to the point where you can identify a natural person indirectly or directly, using like a cookie ID or something as your key, then that becomes personal data. That key would become personal data along with anything else that's collected around it. Now, not so fast with obviously any analytics platform is going to utilize cookies. Those are going to be covered under the e-privacy directives. So we need to make sure that there is transparency, that cookies are being used and that users have the ability to opt out of any sort of analytics tracking as well. For digital media and advertising, it's a little bit more of a gray area. It's a much richer data set of personal and behavioral information oftentimes. So that cookie profile or those cookies IDs are likely to be treated as personal data. And there's also some profiling occurring. Now, as mentioned, that profiling is not going to lead to an adverse legal harm or a significantly adverse effect on a user. So the additional profiling provisions should likely not apply. So we are dealing with personal data in the analytics space, in the digital media and advertising space. So what are the first steps? What do we need to do? Number one, on your website or on a client's website, there has to be an understanding of all the different digital marketing and advertising platforms. If we don't know what personal data is being collected or potentially being collected, we're not going to be compliant, and we could have some really serious problems. So we need to do something like a tag audit or an audit of our existing contracts and really dig into what are the platforms on our site, what data is being collected, where is it being shared, where is it going, and really understand those things and making sure that everything is compliant under the new regulations. So what this means for you, for each platform that's loading on a site that's collecting personal data or collecting cookies or collecting behavioral information, we need to understand, one, is that data that's being collected, could it potentially be classified as personal data under GDPR? If so, what is the lawful basis for processing? What are the rights of the individual being adhered to? Can you demonstrate adherence to the 6 different principles? Is that documentation in place? Is all of that logic documented out so you have a defensible position? And then finally, is everything properly documented in your privacy notice? If you're looking at these questions and I don't know is the answer, then you really need to understand and do an audit of those different platforms that are loading on your site and then start walking the data and going through these different items. And we can use that information that we previously covered to make sure that you're covered. Moving forward, we also need to start building in some of these GDPR principles as part of the evaluation part of purchasing and onboarding of any new marketing analytics platforms. Again, walking through those different steps. Is personal data being collected? What is the lawful basis for processing? If it's consent, are all the necessary aspects of consent being adhered to? If it's legitimate interest, do I have everything? Do I have an actual legitimate interest? And is everything documented to be defensible? Important to note that all associated processors and controllers, making sure that they are also GDPR compliant. Again, as we went through, the on us at the end of the day is on the controller. So you have to make sure that anyone else that you're then sending or sharing that personal data with, that you have determined the means of collection from the user, is also compliant, because it's going to come back on you. Making sure the data sharing agreements are in place, and I cannot stress enough the importance of maintaining documentation. Have to have a defensible position, need to be able to defend yourself, have to have documentation in order to be able to do that. And then finally, we need to be able to monitor for any new unvetted and unauthorized platforms that are popping up, making sure that that compliance is also in place for those. So that was a lot. But now I'll skip the summary and just kind of jump straight into the Q&A. So if you have any questions at all, please drop them in the question pane. I know we're technically out of time. I still have a few minutes, so I'll go through all the questions that are posted as of now, and then anything else I'll follow up with via email. One quick note, as I aggregate those questions together, we do have a follow-up webinar to this. Everything non-European organizations need to know about GDPR. We're covering a lot of the same principles, but also covering a little bit more when it comes to data sharing and how cross-country, third country plays in. So quickly for questions, the first one here, what about small and medium businesses? So instances of less than 1 million turnover. I'm assuming that's in reference to the fines and the administrative penalties. The purpose of the law and the governing bodies have stated this, that the fines are meant and the penalties are meant to be a deterrent, to get people's attention. They're not meant to put people out of business. So as I went through, there are some different considerations in place when it comes to those different administrative penalties, such as what were the safeguards that were in place, what did your processes look like. Another part of that is how large is the business. They're not going to put you out of business unless you're doing something super, super egregious. But yeah, good question. Next question, if publisher has an email ID and then that data is used to target audience on Facebook, is it under GDPR compliance? So an email ID would fall under that classification of like a pseudo-anonymized data point. And if you remember back to one of the first items centered around GDPR, can it be used to directly or indirectly identify an individual? I would argue that because you're then using it to target on Facebook, which targets literally people and all of their personal information there, that email ID is being linked to an additional larger data set that is then identifying that person. So you're using that email ID as an indirect identifier. So yes, it would fall under GDPR. You would want to make sure that you either determine that your lawful basis, consent, or legitimate interest, and then walking through the steps of making sure that it's compliant, and then reflected also in your privacy notice and giving individuals the ability to opt out. Cool. So I think that's everything that we're going to have time for. As I mentioned, if you have additional questions, please don't hesitate to reach out to us. We're happy to help. If you have any questions about like a tag audit, in order to be able to get the process started, again, reach out to us. Happy to help. Thank you all again for joining our webinar today, and we hope to see you on future webinars in the future. Thank you all. Have a great day.